We have Carol from Huntington on the line. Carol, good afternoon.
Good afternoon.
What's your question for Dave this afternoon?
Well, I had a question regarding medical malpractice cases.
Okay.
I've heard in Indiana, unlike some other states, that someone who is injured as a result of medical malpractice, say in a hospital or nursing home, they can't file a lawsuit in court, but instead has to file that case before a panel of doctors. Can you explain the reason for that?
It's a good question.
Yeah, that is a good question. Indiana has sort of a unique set of laws that govern medical malpractice. In most states, if you have a medical malpractice case, you can file that case directly in court and begin the process with the court system. In Indiana, most medical providers are what we call qualified providers, and they're entitled to the protections of the Indiana Medical Malpractice Act. And what that means from a practical standpoint is the case has to be filed with a medical review panel, which consists of 3 medical providers who vote on the merits of that case before you can file your case in court.
Really?
So it's been in effect since 1975. It's unique to Indiana. We also have some interesting laws that govern medical malpractice, such as caps on damages. Most people do not know in the state of Indiana there is a medical malpractice cap of $1.25 million, regardless of the amount of harm that is caused by a doctor or hospital. The most you can ever recover in a medical malpractice case in Indiana is $1.25 million, which is, in some cases where you have catastrophic injuries and damages, it presents a very unique hardship to the victims of medical negligence because they're capped out on their recovery. So we have some laws in Indiana that make it very advantageous to practice medicine from a legal liability standpoint in this state.
Okay. Carol, does that answer your question?
Yes, it does. Thank you so much.
Okay. Thanks so much for calling.